Hello, everyone. My name is William Daniel, and I have the honor and privilege of serving as your prosecutor for Union County. And I want to thank you for joining us here today, albeit virtually. Each quarter, at the direction of the New Jersey Attorney General, each of the 21 county prosecutors' offices located throughout New Jersey host an event for members of the community on topics of public interest. Called the 21 County 21st Century Community Policing Project, these events aim to strengthen the relationship between law enforcement and our community by addressing areas of concern before conflicts arise. Now, previously, events have covered everything from how to access services for veterans, to police use of force, to combating bias incidents amongst children. Today's event will highlight a similarly important initiative, New Jersey's Extreme Risk Protective Order Act, a potentially life-saving law enforcement procedure. Here to educate us today more on the Extreme Risk Protective Order Act, also known as ERPO for short, is the director of this office's Pre-Indictment Division, Tiffany Wilson. Now, it's impossible to briefly summarize the wide variety of important work Assistant Prosecutor Wilson does at the Union County Prosecutor's Office because her impact is felt in agencies across the county. Tiffany has served the people of Union County as an assistant prosecutor since 1998 and currently serves as the director of the Union County Pre-Indictment Division, Union County Prosecutor's Office Pre-Indictment Division. In this role, Prosecutor Wilson oversees the detention unit, the predisposition conference unit, our special offenders unit, numerous screeners in this office. She oversees the expungement unit, forfeitures, and all diversionary programs that fall within her purview, including the mental health jail diversion program, the veterans diversion program, and drug court. Tiffany is also a state-recognized instructor, teaching police academy recruits how to properly interact with special needs individuals, as well as routinely overseeing the instruction of all of Union County's officers on mental health matters from the CLEAR Institute's training programs, as mandated by the New Jersey Attorney General's office, and teaching at events for prosecutors across this great state of ours, the state of New Jersey. In addition to countless other responsibilities, Tiffany, that is Assistant Prosecutor Wilson, is also responsible for various other matters within the office. She is the Union County Prosecutor's Office's expert on all things related to extreme risk protective orders, the topic of today's event. Extreme risk protective orders, commonly referred to as ERPOs, that's the topic of today's event. And Ms. Wilson, Prosecutor Wilson, I want to thank you for joining us here today. Okay, Prosecutor Wilson, how are you?
I'm good.
Great. Thank you for being here today. For the individuals joining us virtually, exactly what is an extreme risk protective order? Can you, tell us what that is?
I can. So the Extreme Risk Protective Order, or what we refer to as the ERPO, is also known in other states as a red flag law or a red flag act or red flag order. And it is basically an order that is available to household members, family members, or law enforcement that in appropriate situations, they have a tool that can remove the ability for an individual to have a possession of firearms in a situation where that person may present an immediate danger to themselves or to the public.
And can you tell us what the definite, I think you might use the word household member. Can you tell us what a household member would be within the confines of the ERPO Act?
Absolutely. So the ERPO Act used the formula that is used for domestic violence restraining orders here in the state of New Jersey. So they define a household member as the very obvious, someone who lives in the house with an individual, but it can also include a current family member, an ex-spouse, an ex-intimate partner, and other individuals that the individual had a close familial relationship or intimate relationship with. So they use the exact same definition as the domestic violence statute does. And then the ERPO law actually added an extra individual. So under the domestic violence laws, only a household member or family member can apply. But in the ERPO situation, a law enforcement officer can also apply for the ERPO.
Why would a law enforcement officer be applying as opposed to the household member or the family member? I'm just curious.
Because sometimes the situation arises in a, let's say, for instance, I'll use an example here in Union County. So in Union County, we've had several ERPOs, and a couple actually have come to light because a medical professional has interacted with an individual who has indicated that they want to harm themselves. They have not indicated that to the family member, so the family member cannot apply. That medical professional has a duty to warn under the laws in the state of New Jersey. So under those laws, they are required to tell a law enforcement officer that a person has indicated that they present a danger to themselves or to others. So perhaps they threatened another individual, a named individual. The law enforcement officer now has that information. And before the ERPO Act went into effect, the law enforcement officer had no mechanism or a very cumbersome mechanism to do something about that information. The ERPO Act allowed the law enforcement officer to use that information and in the appropriate situation apply for an order and act on the information. So if the order was granted, they could remove firearms from that individual and hopefully save that individual's life. So sometimes that's a situation where a law enforcement officer may be the appropriate applicant for the ERPO. In other situations, sometimes it's just the family dynamic. You have a loved one who is very concerned about their loved one. They feel that they are presenting an immediate danger to themselves or to others, but their applying might add to the negative dynamic that is happening. And so sometimes it's the best option that a law enforcement officer is the person who actually makes the application so as not to exacerbate the situation and make the family dynamic worse.
Thank you. What if you don't fall within the definition of a household member and you're concerned about someone's safety? What is there available under this act, if anything, for one to do?
So if you don't fall under the definition, you yourself cannot apply. Obviously, we always encourage individuals who have information or have concerns to report that to the appropriate agency. Sometimes that will be a medical professional, oftentimes it's going to be law enforcement. Law enforcement will use the tools that they currently have. They will investigate, they will get information. They may take sworn statements from that individual and find out how they know the information they know. And if the law enforcement officer, based on the information provided, believes that they have probable cause to believe that the person that they are discussing presents an immediate threat to themselves or to someone else, or to the community at large, the law enforcement officer can then apply for an ERPO. Now, if they don't meet that standard, the law enforcement officer will still use the tools they've always had to attempt to protect that person and protect the public. And that might include, let's say, calling out a mental health screener to have the screener come and evaluate that individual and perhaps make suggestions regarding mental health treatment. And it might involve alerting a school of information where the officer doesn't have probable cause but wants the school to know that certain information. So they'll use the tools they already have, but if they have probable cause based on the information provided, let's say by a neighbor or someone who doesn't meet the definition of someone who can apply for the ERPO, the law enforcement officer can, and under the statute, if they have probable cause, must apply for the ERPO themselves.
Okay, thank you. I had another question, just backing up, focusing on household member again, the definition. Does that include one who is in a dating relationship or had a dating relationship with someone? I know under the Prevention of Domestic Violence Act it does, and I was just wondering if it included that same category.
It absolutely does. It also it includes someone who someone may be pregnant, so they have a child or a child to be in common.
What are signs that a loved one may be at risk of causing bodily harm to themselves or others with a firearm, and that perhaps an ERPO should be filed? What are some of the telltale signs?
So I want to be very clear that the ERPO Act does involve an immediate risk right now. So this is not a thought in the future that this might happen. It is it is emergent. It is emergent for a reason. This is an immediate act. And in most situations, we find that, quite frankly, the person tells someone. And that's our number one sign that there is an issue. A person verbalizes to another individual that they intend on harming themselves or they intend on harming others. It can also come up in a situation where someone has posted something on the internet or has written something. So sometimes a school comes across something that someone has written that makes them believe that they may be intending to harm themselves or others. And because we're talking about household members and family members, obviously somebody's going to be looking at changes in behavior. Somebody who maybe has removed themselves from their support system, has been starting to use or increasing their use of narcotics or alcohol. Those are all potential signs that that person may become a danger to themselves. And again, for the ERPO itself to be used, we're talking about an immediate risk, but those are signs that a loved one should pay attention to and can direct someone to the help that they potentially need. So maybe they need intervention as it relates to their substance use, or they need intervention as it relates to their mental health. And those are things that law enforcement can also help direct somebody, even if they don't meet the requirements of an ERPO. So it's really about, we hear the adage all the time, if you see something, say something. It's the same thing as it relates to a loved one. You want to make sure that if you're seeing changes and changes of concern, that you're intervening near the beginning. We never want to get to the point of the ERPO. It's just a tool that we can use, but we can all take steps to help somebody get the help and support that they need.
How can a member of the public begin the process of filing an ERPO petition? What can you tell us about that process?
So the ERPO is basically divided into two different categories. There's the temporary ERPO and the final ERPO. And because we like to use acronyms here in the state of New Jersey, it's the TERPO and the FERPO. Not necessarily the most inventive words, but they do their job. So in order to apply for a TERPO, an individual would go to either their county superior court, and during regular business hours, and they can apply there. So if they meet the requirements, so they're a family member, household member, or law enforcement officer, they can go immediately to the superior court and they can make an application, or they can go to their local police department and make an application there. The way that the TERPO is set up, it has to be filed in the county where the person you're filing against lives. So we call that person the respondent. So the person who applies is the petitioner, the person it's against is the respondent. So it should be filed in the county where the respondent lives. But if a person has information and needs to make a filing, every law enforcement agency in the state has the same access, and they can assist an individual in making an application. So they can go to their superior court in their county, or they can go to their local municipal police department or local law enforcement agency, because you can go to the county police as well, and they can make an application there. They're going to provide information. They may provide testimony if they are appearing before the court themselves. If they're making the application directly to a law enforcement officer, that officer may take a statement from them. It will be a sworn statement. The testimony, if they are called on to testify, will be sworn. It's just a protection to make sure that everybody's telling the truth and following all of the rules and not using the ERPO in a way that it shouldn't be used. But it's relatively simple, and the way that the ERPO or the TERPO is set up is that it's an expedited hearing, which means it's to be heard as soon as possible. So if we are after business hours and a person has gone to a law enforcement agency to make the application, there are judges that are on call who will hear the application right away. The same process that is used in a domestic violence restraining order. So that's how you get the TERPO.
Yes, so one can make an application 24 hours a day.
Absolutely. And it was absolutely set up that way. In fact, the statute specifically says in an expedited manner. It specifically doesn't list the time, and the reason for that is because everyone who was part of the legislation wanted to make sure that everyone was aware that as soon as this can possibly happen, this is when it should happen.
So somebody goes and applies for the ERPO, and then the case moves along in our system, our court system. Can you just give us, some background on what occurs after one applies for the ERPO?
Absolutely. So the turbo, so the temporary, that first step, the standard for that is good cause. So once the court finds that good cause has been shown, that the person presents an immediate danger to themselves or others, they will enter the order if they find it appropriate. Once that happens, within 10 days, a final, or a FERPO, is scheduled, and that is scheduled in Superior Court. So the court will list that down for a hearing, and then at this point the respondent is noticed that they can come to court and they can be heard on the matter. And then a hearing, somewhat similar to the TURPO hearing, but with additional information. So by this time, if there's additional information, maybe it's documented information in papers, or sometimes it might be testimony. It might be past history related to the individual. All of this can be brought before the Superior Court judge, who will hear the hearing to determine whether or not it is appropriate for a FERPO to be issued. And again, at this point, the respondent has every right to be heard on this matter and provide any documentation or other evidence that they want the court to consider in that situation. It's not intended to be difficult. It's just intended to be thorough and to make sure that the court can make the appropriate decision.
So someone applies for an emergency, an extreme risk protective order. The a TURPO is granted if a judge determines that a TURPO should be granted, right?
Correct.
And then is it the goal to have that respondent, the person who's the subject of the TURPO, served right away? How does that happen? Does law enforcement do that?
Absolutely. Yep. So if the TURPO is issued from the courthouse, the court's computer system immediately notifies the appropriate law enforcement agency that a TURPO has been granted, and that agency is then responsible for service. Our sheriff's officers here in Union County also assist in that, in making sure that service of the TURPO happens and that the appropriate law enforcement agencies are notified and they know that they have to file. Obviously, if the law enforcement officer was involved in getting the TURPO, so they testified or they were doing the TURPO at the police department with a judge on the phone, they will already have that information and they are to go out and immediately attempt to serve that information, and that TURPO will have the date of the FERPO hearing, so 10 days later. Sometimes that has to get moved because sometimes we are unable to serve the individual either because they can't be found, or sometimes in some situations the individual may, let's say there was a mental health component to it, the person may actually be receiving treatment. And then the court works with us on getting a new date for the FERPO hearing and making sure that the respondent knows about the hearing and knows that they can come and be heard.
And in the event the final FERPO hearing, the FERPO hearing is postponed for whatever reason, does the TURPO remain in full force and effect pending the outcome of the FERPO hearing?
It does, and the TURPO itself prohibits any individual that it was filed against from possessing a firearm. So in addition to trying to serve the TURPO and making sure that we have all of the firearms that that person may in fact have, we also immediately notify the state police that one has been issued so that they are aware and so that they can't go out and purchase another firearm as well. So there are safeguards for that. But the TURPO remains in effect until it is no longer in effect, either because a judge has issued or failed to issue a FERPO after the hearing.
Okay. So tell us, if you know, how can an ERPO, which is whether it's a TURPO or an ERPO, no, I apologize. Whether it's a TURPO or a FERPO, how can an ERPO, an extreme risk protective order, be terminated?
So a turbo is terminated when a judge finds that the standard wasn't met for a FERPO. So if the hearing is set and the judge says, yes, you met the good cause standard, but you now have not met the higher standard that is necessary to issue a final, then it will automatically be terminated, and weapons will be returned if they were seized. Any identification cards or permits will again be activated. So that happens pretty automatic once that a finding that a final is not appropriate is made. Once a FERPO, so once the final is issued, the petitioner or the respondent can make application to the court requesting that the FERPO be vacated. There will be a hearing on that. The petitioner has the right to be present. Obviously, the respondent would have the right to be present. The law enforcement agency that applied would have the right to be present, and the prosecutor's office has the right to be present and to be heard at that hearing. But a judge can make a finding that the final is no longer necessary, and then any firearms that were seized would be returned to the individual.
Thank you. Is there anything else you think a member of the public, member of our community would benefit from knowing about ERPOs?
Well, I think just knowing about them in general, I think the tools that we have that can help prevent someone from harming themselves or harming others are only as good as how many people know about them and and know that they can use them. So I think knowing about them is probably the most important thing to know. I think I did mention it before, though. Nothing is the answer to everything. So I think it's always important to make sure that everybody is looking out for the people that they love and the people that they care about. So it's important to report or to get someone help who needs help. So again, if somebody is struggling with substance use or struggling with mental health, I think early intervention is always the best way of dealing with it. Waiting until we get to this point is never a good idea. But once we get there, I think people should know and that every law enforcement officer in the state is trained in this. They know how to do it. They can provide assistance. It's just a matter of asking, and they will provide the information that is necessary to make this happen. And then I really think it's important for people to know that there are safeguards along the way. New Jersey spent a lot of time in developing their red flag or extreme risk protective order law. They made sure that there were protections for the respondent to make sure that every step of the way decisions are being challenged and are being reviewed to make sure that if we're going to take away someone's firearms or right to possess a firearm, that we're doing so fairly, and that we're making sure that we're considering all of the factors that need to be considered. And every step of the way, there is a way that a turbo doesn't, or a turbo or a FERPO doesn't get issued. And so fairness really was part of the consideration when they developed this law. It was really just meant to deal with that emergent situation where someone could harm themselves or harm others. And our experience here in Union County, I can't speak for the entire state, but the vast majority of ERPOs that we've seen since the law came into effect have been preventing someone from harming themselves. And we've had situations where the family member has brought the case to the attention of law enforcement. Law enforcement has assisted and in some cases either joined or actually filed for the extreme risk protective order on behalf of a family member who was concerned about their loved one. And all of them thus far, and hopefully this will remain the case, we're extremely appreciative of the fact that law enforcement not only helped them, but had an immediate tool to get the firearms out of the home because they really did believe that the person was going to harm themselves. And at the end of the day, I think that's what we here at the prosecutor's office and we in law enforcement want to do to the extent that we can save lives by something as simple as an order. that's being reviewed by a court. If we can do that and we save a life, I think we all feel like that was a good day.
Thank you very much. Ms. Wilson, you're this office's expert in many areas of mental health related issues, diversionary programs. You're the expert in ERPOs. You have other prosecutors that work with you in your unit that are also well versed in this area too, I think, right? I just wanted the public to know.
We do. So again, because these are 24/7, there's always an on-call assistant prosecutor who is assisting law enforcement on the back end of things to make sure that everything works smoothly. We work very closely with the courts to make sure that everything works smoothly. And then within the office, every assistant prosecutor has received training regarding the ERPO, but in the pre-indictment division, which you indicated that I supervise, every one of my assistant prosecutors can and does appear in court on these matters because they are emergent and because they can come up on any day at any time. We needed to make sure that we were pretty nimble within our own office. So there will always be an assistant prosecutor who can assist the law enforcement officer in assisting the public in getting these orders dealt with in an expedited manner.
Thank you. And on the law enforcement side, there's always someone at the local police department who's on duty, who's familiar with these procedures too, I think, right? Every shift on a police department has officers trained in this area.
Actually, when the statute came into being, every law enforcement officer had to receive the training, so they all have it. I think you mentioned that I teach at the academy, so those officers get it when they come through the academy. But every department, every law enforcement officer has the training. And again, because there's a on-call assistant prosecutor available to those law enforcement officers when they need to be reminded or just need to make sure that there haven't been any updates that they may have missed at some point, the assistant prosecutor can assist them. And the administrative offices of the courts also does a really good job in having training videos available sometimes for the public, sometimes for law enforcement. So even at 2 o'clock in the morning, if somebody wants to remember how the process works, they can quickly click onto one of those videos and just be reminded of what they learned, because perhaps it's been 2 years and they've never had one of these and they just need a quick reminder. So all of those tools are available. So there's always someone available to help. And because people can apply at the courthouse as well during regular business hours, the staff at the courthouse is also trained in assisting with these and will help the individual file on the court's electronic court system as well.
If someone wanted to come to the courthouse complex here in Elizabeth during what I'll call the normal business hours, Monday through Friday, where would they actually go? Where do they go to make the application? Like what building? There's 6 buildings here.
So they would go to the criminal division, which is in the tower. It's the big courthouse. It's the one that looks like the courthouse. So they're going to go to the tower and they'll ask the guards at the door to direct them to the criminal division or to let the guard know that they are there to file an extreme risk protective order, and someone in the courthouse will help direct them. Oftentimes, sometimes not in our current COVID world, but oftentimes there's actually volunteers that help direct individuals that sit near the doors of the courthouse to help direct individuals.
And this might seem rather obvious, but it bears repeating, there's no cost to do this. This is a service that the community is afforded.
Absolutely. There is no cost whatsoever to filing. And again, it can happen at the courthouse or it can happen at your local law enforcement agency.
Yes. And one need not come to the courthouse during normal business hours to apply. One can go to their local law enforcement agency. I mean, we're here in Elizabeth, and the opposite end of the county is the beautiful Queen City, Plainfield. One who lives in Plainfield need not drive the 15 miles to Elizabeth. They can go to their local police department during daytime hours too, correct?
They can. So I will say I cannot speak for the entire state of New Jersey, but here in Union County, we have an agreement with our criminal division that a sitting Superior Court judge will also hear the application telephonically with the assistance of a law enforcement officer for this exact reason, because that 15-mile trip from Plainfield to Elizabeth probably takes a little bit longer than many of us would like. And we want to make sure that people aren't deterred from applying because we're taking up too much of their time. So they have agreed that they will also hear the application telephonically with a person sitting in a local police department as well.
Okay, I want to thank you for your time here. And ladies and gentlemen, members of the community, this concludes our interview here today. This is part of an educational series that we will continue to roll out here at the Prosecutor's Office to proudly comply with the 21 County 21st Century Community Policing Project. Thank you. You're the members of our community, and we need you. We need you. It goes back and forth. Many people think we need law enforcement. Well, we need you. We're only effective as our community's involvement with our agencies allow us to be. And this is part of the exchange of information, the educational process that will continue to make Union County a beautiful county to live in and reside in, ensure our ongoing concerns regarding safety. Thank you very much. Thank you.
Thank you.